Hi, everybody. Thank you so much for joining us today. Today, we're talking about top 10 HR compliance mistakes and how to avoid them. We were initially going to have Leah join us from Woods Rogers, but she had a family emergency come up. And so we're very, very fortunate to have Victor Cardwell joining us from Woods Rogers today. So, Victor, thank you so much for being here.
Jocelyn, absolutely my pleasure. Sorry, Leah can't be here, but I'm happy to stand in her stead.
Thank you. So really quickly, we'll just cover the agenda, introductions. We'll talk a bit about why compliance is more challenging than ever, and then jump into those top 10 HR compliance mistakes, followed by Q&A at the end. Just to introduce yourself, Victor, first, if you wouldn't mind.
No, happy to do so. Again, you guys, I'm Victor Cardwell. I'm chairman of the board and chairman of our labor and employment group at Woods Rogers. And I've been practicing law in the Commonwealth of Virginia and frankly, luckily across the country since November of 91. And this labor and employment, we both are echoing. Well, thank you for telling us that. I will see if I can reduce the volume, and I'm going to count on that person to tell us again that I'm not echoing. Am I echoing now? Yes, we are. Okay. That would normally imply a second microphone or a third microphone. I don't have another microphone going.
It
That's for
looks like
sure.
we're not echoing for some
Not
others.
echoing for me. Thank you,
Okay.
Jeffrey. And thank you, Erica. So it might be, not to be personal, it might be a personal problem. Uh, Uh, but yeah, listen, well, I'll keep going then and just tell you again, I've been doing labor and employment law management side for well over 30 plus years. I'm very fortunate. I do labor and employment law. And just to very quickly, labor deals with unions and that black letter law that deals with unions and collective bargaining and the like. The employment capacity is what we're talking about today. And that's all the things that are causing headaches for HR professionals like yourselves.
Oh, thank you, Victor. And just to introduce myself, my name is Jocelyn King. I'm the CEO and founder of a company called VirgilHR. VirgilHR is an employment and labor law compliance software platform that's available for HR practitioners, and particularly those that are managing multi-state employees. We'll learn a little more about VirgilHR at the end, but I'm really excited to be here and very excited to be here with you, Victor.
My pleasure indeed.
So we'll jump right into why employment and labor law compliance is more challenging than ever. And I don't think that this will come as a surprise to many of you on this call. The first is we're seeing more and more multi-state workforces, and that ends up creating quite a bit of complexity for employers and HR professionals because what matters from a legal perspective is where the employee is working, and that might not be where necessarily your office is, for example. So you might be familiar with Maryland law, but you could have an employee in Colorado and not be as familiar with Colorado law, and that's where it gets a little bit sticky. Then we have, of course, and this kind of comes with that territory, remote and hybrid employees. Hybrid employees gets really tricky as well. Maybe they're working 2 days a week in Virginia, 3 days a week in Maryland. What do we do in that situation? Of course, we have rapidly changing laws. These are happening at the federal level, but particularly at the state and local level as well. Increased enforcement, employee awareness to workplace rights, and of course, litigation trends as well. So, what's the reality of HR compliance today? 51% of small businesses say compliance is hindering their growth. And among some of these other statistics here, something that I thought was really interesting is over here on the right-hand side, what we're seeing is a rapidly evolving environment. 19 states in 2025 enacted pay transparency mandates. 150 laws govern background checks, and there are more than 59 localities with unique minimum wage rates, which is up from 5 in 2010, which is just crazy.
Yeah,
So a lot
Jocelyn,
to
those
keep
are
up
those
with.
are incredible statistics. I don't want to
Yeah.
interrupt you, but I would just tell people, particularly if you're practicing in multi-state jurisdictions, what's happening at the state level is unprecedented in a lot of places. So when Jocelyn gives you those statistics, you should all be looking very carefully at what is happening in your work environments and determine how you can ensure proper compliance because I deal with it on a consistent basis and it is a devastating issue.
Yeah, absolutely. So, what are consequences to this? We have financial and legal exposure here. 1 in 5 companies is facing an employment related lawsuit each year. That's an astronomical number. I remember maybe 5 or 6 years ago, it was more like 1 in 10. So, we're seeing more litigation coming through, more complaints coming through. And some of that could even be from just more employee awareness over workplace practices and laws. A lot of other metrics in here that I won't go into, but I do think it's really important to point out something in particular. 33% of organizations incur penalties annually, which is just astronomical. And 25% plus report fines related to multi state compliance. So there's a lot of risk to getting it wrong. And the risk can be damaging, not just on the financial or legal side, but also on the reputational side to your business as well.
Absolutely. And Jocelyn, I'll just add on that 1 in 5 companies facing, apologize for a dog, 1 in 5 companies facing employment litigation. The threat and problem of pro se litigation today is worse than ever before. AI has made plaintiffs, lawyers, individual plaintiffs, lawyers, and it's much worse than dealing with law firms, as much as I hate to say that as a management attorney. It's an absolute fact.
Yeah, it is. So, Victor, I'll pass it off to you next, the top 10 compliance mistakes, and I'll be running through the deck. So if I'm too slow at progressing to the next slide, just let me know.
Jocelyn, you won't be. I've seen a number of people comment about the video recording and whether it's going to be available. I'll defer to you on that one.
Yeah, so the recording will be sent out a few days after the webinar today.
Okay, good deal. And I saw somebody ask about notes as well, and I'll defer to you on that. I'm a notes-free kind of presenter, but let's talk first about some of the top 10 compliance mistakes. And I'm going to start off with a very easy one. It's almost low-hanging fruit, but I'm going to tell you every employer who is represented on this call is in violation of this law. The Fair Labor Standards Act, and I said that with great sincerity and not hyperbole. The Fair Labor Standards Act, which was enacted in 1937, is the second oldest labor/employment law on the books, and it is observed in compliance by most, but each and every one of us are in jeopardy of making mistakes with regard to the FLSA. And I would suggest to you, this is an area where people should pay attention to on a consistent basis. And we'll talk about some suggestions or ways to remedy them. But let's start off with SABLE. The question of exempt versus non-exempt, or to be or not to be is the question. I like the Shakespearean twist here. Sable, in our little scenario, is a process engineer. She has an annual salary of about $68,000 a year, so a good salary. The plant has 16 process engineers. Let's assume for the sake of argument that there are many other types of employees, but 16 process engineers. For the first year in 2025, Sable worked with other process engineers to build 2 manufacturing lines and troubleshoot issues. There were multiple obstacles in building the lines, and Sable worked on average 55 to 65 hours a week. And for any of us who work in an exempt capacity, we know that's pretty common. On November 1 of 2025, she asked you, HR, can she get overtime pay? And ultimately, she was denied. On December 1, 1 month later, the line's up and running. Process engineers returned to office work running analytics and developing software updates to improve line efficiency. On January 1, just another month later, you've convinced the plant to give each process engineer a $4,000 bonus for their hard work on the lines. During the first 3 months of 2026, Sable worked less overtime, 45 to 55 hours, so still 10 hours a week, but sometimes filled in as a tech since they were short-staffed. Now, in my scenario, I want you to assume that a tech would probably be a non-exempt employee in most situations. Sable now files a Fair Labor Standards Act lawsuit against the plant, naming you as a defendant. Because under the FLSA, I want you to be very clear about this. This is one of the few laws I deal with as an employment attorney where your liberty is actually at stake. There are people who actually get arrested for violating the FLSA, the Fair Labor Standards Act, and that's frankly a horrifying proposition that should scare any number of us. So let's look at what risks are presented. All right, Jocelyn, to exempt, not exempt, to be or not to be. First claims presented, misclassification. Now, Here we have in parentheticals class actions or collective action. All of you have heard of class actions where multiple plaintiffs are suing somebody. Under the FLSA, it's actually called a collective action. And Sable claims she was misclassified as being exempt, and you could believe that she's going to sue on behalf of the other 15 other process engineers she represents. I'm going to suggest to you that a process engineer, when working in their purest capacity, is probably going to be a professional exempt employee. You should think about these exemptions very carefully, and I'm going to caution you here and digress for just a second. Under the Fair Labor Standards Act, there are 4 primary white-collar exemptions. There's the executive exemption, who's a supervisor. There's the administrative exemption. Now, the administrative exemption is a person who does back office work, not the work of the organization, right? There is also a professional exemption, and I'm going to tell you that the word professional in 1937 doesn't mean the same thing it means today. In 1937, probably anybody who had on a white shirt and a tie was going to be deemed professional exempt. Today, it really means a person who's had an extended course of study, who works in a specialized area. Think certified engineers, think lawyers, think doctors. All of us on this call should conduct ourselves in a professional manner and are professional, but it doesn't mean we qualify for the professional exemption. Then finally, you'll have your outside salespeople who can also qualify, among other things. But here, I'm going to suggest to you that we're probably going to be okay with regard to the classification of process engineers. Now, where we may be at risk are issues like when she worked as a tech for a period of time, how much time was involved, did she lose her exempt status or not? In our scenario, I'm suggesting she probably didn't. Keep in mind, your exempt employees can do non-exempt work, but they can never exceed more than 50% of their time in that non-exempt capacity without jeopardizing their exempt status. Under the FLSA, these exemptions are classified on a weekly basis, but you don't want to rely on that. You really want to be clear about who's exempt and treat them as such at all times. That means they work in those capacities I told you about. They're paid a certain salary level, right now about $37,000, $38,000 a year under federal law. And they actually are paid on a salary basis, i.e. they receive the same amount of pay in any work week in which they work. That's a very important thing. You don't change their pay. You don't dock their pay. Those are things we can talk about in greater detail on another webcast. But for this one, just sort of keep those simple rules in mind. Number 2, an overtime. Sable claims she's not been paid overtime for all hours worked over 40 in every work week. Again, a collective action. She's asking this on everybody's behalf. Don't forget, she was working 55 to 65 hours for the first month or two, and then ultimately down to just over 10 overtime hours a week. Though the good news is, if you're properly exempt, you can work as many hours as necessary to get the job done. And I'm going to suggest to you, as a process engineer, she was probably exempt. Now, it's always a risk, and this is one of the biggest concerns, Jocelyn, that every one of our attendees should be thinking about, and that is, if I go back and think about who's properly exempt, and that's going to be some of the homework for the day, and I go back and look at my entire workforce, and I say, well, who's exempt? And you should list those people out. And then you ask yourself, is that person really exempt, or have I just sort of taken a historical mistake and continued it? And that happens a lot. Many of our HR professionals have walked into positions that existed long before they got there, and they've sort of picked up the ball and run with what someone left. And unfortunately, a lot of people make this mistake and they believe, well, it's always been this way. Or they make the mistake and think, well, somebody else is doing it that way in our same competition or same competitive business, so this must be the right answer. Trust me when I tell you, wrong is wrong. Doesn't matter how many other people say it, they're wrong. But generally speaking, I think we're going to avoid an overtime liability as long as she's working as a process engineer, and even during a short time when she worked as a tech, because I'm going to work on the assumption in my scenario that she was not working more than half the time. Unpaid overtime premiums. She claims the company should have included the $4,000 bonus in her calculation. We're going to spend some time talking about bonuses. Generally speaking, what you have to keep in mind is this. For a non-exempt, now not an exempt, but for a non-exempt employee, all compensation they receive in any particular work week, or that covers any particular work week, generally speaking, goes into their regular rate of pay. Those are magic words. It's the regular rate of pay that determines how much an overtime is paid. It's not their hourly rate or not their salary divided by 40. It's the regular rate of pay. And in a lot of positions, regular rate of pay can include premiums and bonuses and additional compensation that may not be part of the hourly rate. Okay? So these are fun things to talk about. The FLSA does get me a little excited because I spent a lot of time dealing with it over the course of my career. And again, it's frankly, it's one that we should all pay attention to. Finally, she claims retaliation. Let me tell you a few things very quickly about the Fair Labor Standards Act. First and foremost, plaintiffs love the FLSA, plaintiffs' lawyers. Why? Because if they get any recovery whatsoever, they will get their attorney's fees. And so their plan, they basically made it a home game for them. Go back to what I said earlier, and that is that a lot of people are violating this law. Frankly, I said every employee on this call, because if I were to go through and conduct a white glove audit, imagine me putting on white gloves and just walking in and checking out everything that you do in your workplace, am I going to find a non-exempt employee who's probably working before they clocked in, who maybe is working after they've clocked out, who maybe are taking lunch, but they got interrupted? All of that's working time. So let's go back to it real quickly. She's going to claim she was effectively demoted to a tech after requesting overtime. I'm going to say she was working. We're going to have good documentation to demonstrate that she worked in a tech capacity because we had gotten in lines running properly and it was a small period of time. So I'm going to claim that we win all these things, but I want you to keep in mind, they're not as quick and as easy as this conversation right here. Right now, our conversation is sort of like one of those hour-long legal shows you watch on TV, Law and Order, where the crime occurs and is resolved by the 53rd minute. It's not how it really works in real life. What are your takeaways? Audit your workforce. Look at your payroll. We talk about regular classification audits. I would tell you that if I had my dream, every HR professional listening to this would look at their payroll and they would put a star beside everyone who is exempt. That means anybody who's not receiving overtime. And what I want to say to you is keep in mind, every employee in America can be non-exempt, every one of them. Don't want to say Elon Musk can be non-exempt, but he could be. His hourly rate would be pretty impressive, but he could be a non-exempt employee. And if he were, you'd be paying him an hourly rate and then you'd pay him overtime over 40 hours. Anybody can be, but not everybody can be exempt. So I'd go back and I'd look at everybody who's exempt and I would ask you, can you justify it? Can you put it into one of those classifications? Look at job descriptions. Make sure they accurately reflect what's happening today. So many job descriptions have aged over time. Technology has changed, the manner in which we work. COVID changed a lot of jobs and the way we do them. So look at those job descriptions, make sure they're up to date. And as a freebie, look at the ADA. Do you have the essential functions listed in those job descriptions? Because that's going to be your first line of defense on a claim. Make sure all positions are properly classified. That goes back to your audit. And then let me say this unequivocally. Overtime. The hardest part about overtime is knowing when people work it. And that means, are you tracking it? How are people tracking time? Most people are not using the old-fashioned timesheet where people put time in. But let me say this out loud. If you have a timesheet or a time tracking system that says 8 hours, 8 hours, 8 hours, that's not a sufficient document. You need a timesheet that reflects when a person comes into work, when they stop working, when they resume working, and then when they leave work. That's what you need. And the timesheet that doesn't do those things is probably going to be subject to challenge. So there are a lot of things we can talk about to be or not to be exempt. Thank you, Jocelyn. Sorry.
No, this was amazing. Thank you so
Was
much.
it? Oh, it's fun stuff. Go ahead.
It it for all of us it is. For anybody else, probably not. But being in HR is it's a special calling for sure. Before we move to the next slide, just for the audience, and I see some of you are using this already. Please use the Q&A for Q&A at the end. Don't use the chat. The chat, we just get a lot of traffic coming through and it's really hard keeping up with the questions. So put all of your questions for Victor into the Q&A section and we'll cover those at the very end.
Sounds like a plan. All right, so let's move real quickly into this idea of bonuses. I mentioned in the FLSA, and we had it in our scenario with Sable, there are two types of bonuses that the FLSA recognizes. There are non-discretionary bonuses and discretionary bonuses. I'll address the easy one first. Discretionary bonuses are ones that you do not have to include into your regular rate of pay. Think the holiday bonus at the end of a year or whatever your calendar year might be. And, or any other time. And that's a bonus. If you look at the slide, it talks about the employer has the sole discretion to pay the bonus. You may decide one year to have it and one year not. The employer has sole discretion to determine the amount of the bonus. And the bonus is not paid according to any pre-existing agreement. Once you violate any one of those three things, what is a discretionary bonus that can be excluded from the regular rate of pay could turn into a non-discretionary bonus. The non-discretionary bonus is the broader sense of money. Again, when you pay somebody money, they generally speaking will be included. That those funds will be included into our regular rate of pay, and in turn subject to overtime compensation for the time frame. It's a simple concept, but I would suggest to you harder to apply than many people think. What I would tell you further is in Sable's scenario, where someone went and just negotiated or made a request for a $4,000 bonus. That sounds to me like a discretionary bonus. They went in, they said, you know what, great work has been done, but we're not tied to any level of production. We're not saying you came into work and did these kind of things, but it was just given. Let's look at our little pie chart over here ever so quickly and just address a few things. If you have a bonus based on attendance, that by definition is based on a quality or quantity of work. And that is now going to be a non-discretionary bonus. Okay. If you have a discrimination that's based on safety, for example, or cleanliness, that bonus is also going to be quantified by somebody. And they're going to be saying, you X worked this many days and you didn't have an accident, and this is the bonus you'll receive. So I'm going to suggest to you that's likely going to be non-discretionary. Now, if your bonus is made based on profits and the determination as to if to give it out and to how much is kept by the company, then that bonus very well could be it could be a discretionary bonus and excluded from the regular rate of pay. So that's a decent treatment of bonuses. What I will say to you further, you guys, is the FLSA has, generally speaking, there's great treatment and opinion letters associated with the FLSA are helpful guidance from the Department of Labor, usdol.gov. And you can find a lot of helpful cheat sheets associated with the FLSA that I'd recommend to you as just a source to look at. But the problem with the FLSA that I want to highlight for you is, unfortunately for you, more times than not, you don't know what all of your employees are doing, and you don't know how your supervisors are handling these situations. And so it's imperative that you train your supervisors about when a person is working and how compensation works. We'll get to that later. Let's try the next slide, Jocelyn, and see how we do there. So we talked about classifications, right? And now here we're going to talk about not only exempt and non-exempt, which I've given you an overview of that, but also the idea of W-2 employees. That's your regular, everyday come to work employees versus a 1099 contractor. If you look to the side, to the left-hand side, you'll see there are W-2 employees and they are 1099 contractors. But the moment you say, I got a 1099 employee, you have made a mistake. And let me say this to you from a wage and hour standpoint. If you even use the wrong vernacular, it doesn't mean that you're wrong in what you're doing, but what it will do is tell that investigator that something may not be quite right. So you want to be real careful about that. And as a practice point, if you do ever find yourself subject to a wage and hour investigation, there are a couple of things I want to tell you right up front. The first is be compliant, be pleasant, offer them a Coke and a glass of water, be as nice as possible, call your lawyer on the other line. I mean, literally call your lawyer. The Department of Labor Wage and Hour Investigator has the ability to knock on your door with no notice whatsoever and has the ability to show you their badge and sit in and watch your operations. So the last thing you want to do is tell somebody, no, you can't come in. You block somebody like that, they have the ability to actually shut you down. So you want to be compliant, you want to be nice, but then you want to try to shuffle them out the door, or you have to call as quickly as possible and say, there's nobody here right now. Can we get back to you? I just give you that as a practice point, something to talk about. Why misclassification is such a big deal? The bottom line is this. Under DOL investigations, wage and hour investigations, all these laws are subject to back pay and certain penalties, and there can also be, again, actions taken by not only a plaintiff individually, but also the Department of Labor Wage and Hour Division could actually sue itself. Not to mention there's state labor departments who might investigate and assess similar penalties. I don't deal with the IRS. Thankfully, I have very good tax lawyers who deal with those issues, but I can tell you again, and every time you look at the top three, you're seeing actions and penalties. That means money going out the door. And the hard part about most of these is you've already paid people a salary. You've paid them a wage. You've paid an amount of money for a certain work done or product done that you've gotten out. And if you have a violation here, you may be paying more money for the exact same work. So compliance is a big deal, and it's just important for us to keep it in mind. You have unemployment issues, and then finally, number five, not finally, but importantly, again, the idea of individual litigation. I'll go to it again. You guys, I'm a lawyer and I litigate cases all the time. I like what I do for a living, but I will tell you unequivocally, we have the best legal system in the world. We do. And it's still, and this is a legal word, Jocelyn, it still sucks because it's very expensive. It's very expensive to start litigation, and it's very expensive to get out of it. I always talk to my clients about exit ramps on a highway. At what point in time are we going to try to get off? We can win. We can win a lot of these things, but at what cost? So when we talk about lawsuits and the like, I love it when my clients say to me, I'd rather pay you than pay them. I love it. And some actually mean it, but most don't. They may not rather pay you for a couple of weeks or months or even months on end, and then they realize, holy smokes, this has gotten very expensive, and we need to find a way to end this litigation pretty quickly. All things we can do, but things to keep in mind. Under number six, individual and collective actions under wage and hour lawsuits, and then parallel state lawsuits for failure to pay minimum wage and overtime. You should never have a scenario, and most of you probably do operate in states that have a living wage versus the federal minimum wage. That's just something to keep in mind. I know Jocelyn can certainly speak to that a little bit later. But all of these also are subject to damages, and those damages can be up to two times the amount of money that you already paid them or didn't pay them properly. And you should keep in mind, under the FLSA, right, the statute of limitations for a normal claim is 2 years. But if it's deemed to be willful, it can be up to 3 years. So there's a significant period of time that could be at play. And what you have to keep in mind is even under Sable scenario, only 16 process engineers. If you were to violate the FLSA with those people, the numbers of hours at 45 to 65 hours they were working and times the 16 people, those numbers add up very, very quickly. So it's just the kind of thing you want to keep in mind. Jocelyn, let's move on to the next. You know, I thought about not putting this in, but I think it was worth mentioning. Again, I deal with a lot of employment laws in many different, fortunately, I guess, jurisdictions. But the FLSA, the Fair Labor Standards Act, is one of the very few that talks about individual liability in such a stark and direct way. They define employer as a person acting directly in the interest of an employer. So therefore, that can be owners, managers, supervisors, HR or payroll. And I don't, it's not designed or intended to scare people, but it is designed to let you know that this is not a law. None of these 10 things are worth, sorry, Jocelyn, I got caught by one of the comments was, thanks for, this is scratching my HR itches. That's good. Get some calamine lotion, it'll help. But the fact of the matter is this law does have the ability to impact individuals. So just be mindful of what you're doing. As we move out of the FLSA, Jocelyn, we'll move over to some hiring because, you know, frankly, you want to, if you start off right and get the right person in, I'll give my colleague Leah, who can't be here with us, credit for this eHarmony idea. You know, she likened it, and I've done a presentation with her or two on this idea of think of hiring like a dating process, except for even better. You want to hire better than you date, right? So when you post for jobs, make sure that you don't have bias. And let me say this out loud. For any of you who utilize a third party or who utilize AI or any type of artificial intelligence to create your openings or talk about the job openings, you're only as good as the system you use. And that's why I'm happy to be here with Jocelyn, because when I've got good professionals dealing with these types of things, I can have levels of confidence. Too often I hear people refer to third parties of things that I don't know if they've been vetted and what kind of experience they have. And they are still going to hold you responsible. They being the Department of Labor, they being our judicial system, responsible for whatever you get out. So that's very important. Posting for jobs. Make sure there's no bias. Make sure you have good language in your job postings. It's so easy to have an aspirational job posting as opposed to an accurate one that describes what the essential functions are of the job, but be aware of it. Know about pay transparency laws. We have, as of July 1, enacted one here in the Commonwealth of Virginia. And I will tell you, it's pretty straightforward, but I had so many calls from clients. It said, list, among other things, the minimum and maximum levels for the job. List it. And then you can have gradations in between. I can't tell you the number of people who called and said, but can I just list a midpoint? Because I really don't have people at the maximum. Well, the law as it's drafted right now, and again, these pay transparency laws, depending on what jurisdiction you're in, they're in their nascent stages. And so how they're enforced and where the violations come from are still to be determined. But I want you to stay in front of those issues, never be behind trying to catch up. With regard to interviews, and you will hear us talk about this from a takeaway standpoint all the time. You train your managers and you tell your CEOs, your operations people, your CFOs, an hour time off the production line for managers will pay them dividends tenfold. And I may be prone to hyperbole with that number because it may be much more. You heard Jocelyn talk about those statistics earlier. If I have properly trained managers, I can avoid litigation, or in the worst case scenario, I can win litigation. Both of those are the places you want to be in. So you train your managers on interviews. I also mentioned the FLSA earlier, and there's so many things I can talk about. You train them on do's and don'ts. Interviews are not a casual conversation. They're not intended for you to ask, how's the family and what are you doing and tell me about your summer. They're designed to get information about that person sitting in that room, and you get information about their ability to perform the job. Maybe you'll glean some information about how they performed previously, but you want to get this information. Be careful to avoid prohibited questions. Questions that elicit information about a disability. The ADA is live and well. And you have to be careful that you don't, again, just engage in casual conversation, because oftentimes we see individuals who come in who are more than willing to just offer information about their conditions. In this era of social media, people will tell you all sorts of things they have wrong with them. And the interview is not a place where you want to have that happen. You can always, instead of asking questions that elicit information about disability, always talk about the job relatedness. I'm not sure what that is. I'll let you deal with that. Asking about inability to perform a job function, i.e., can you perform the essential functions of the job? The job requires you to be here at 8 o'clock in the morning. Can you get here? Those kind of things. Avoid questions or comments that can be used as an inference for discrimination. You know, it is interesting that oftentimes, that was my fault, oftentimes people are asking questions and then they'll make comments. And, you know, as a person who talks a lot, myself included, I know sometimes you can make those comments, but if you're not trained, you can make comments about things that can literally lead you down a bad path. Making the offer. Always hire the most qualified candidate. The most qualified candidate will save you from a lot of bad candidates. Document why. We love good documentation. It doesn't have to be the person with the most years of experience. Qualifications can come in many different forms, but you document why. You always condition your offers. Please don't let someone start work before you've completed your background check and before you've done the things necessary. Too often we hear operations say, well, I had them start last week. I know we haven't started the background check. Then the background check occurs and we get a problem. That's a problem that we should avoid. Make fair and equitable compensation decisions. Again, you got transparency laws. Be careful that you don't use an applicant's past salaries, their history, as the barometer for what you're going to pay them today. Historically, the EEOC has demonstrated that women and minorities oftentimes undersell themselves. And so that could be a perpetuation of discriminatory conduct if you're not careful. So just be mindful of it. You want to talk about it very quickly, and Jocelyn, you keep me in mind on time. I'm looking at it. I think we're okay, but you keep me in mind. This is a good pay equity case just to pay attention to it and look. It came out of here again, the Commonwealth of Virginia. It was Professor Zoe Spencer. She was a professor at Virginia State University. For those who might be familiar, it was a historically Black college and university, an HBCU. She was promoted to a full professor of sociology in 2013. She earned an annual salary of $70,400. She basically sued, and you get that. That's how we got here. And she used her male comparators. She had a Dr. Michael Shackelford and a Dr. Cortez Dial. And they both earned over $100,000 a year. So you stop right there and you ask yourself, huh, I have this female who's making $30,000, which is a very significant sum less than her two male comparators. But both men were former high-level university administrators, one a VP who moved back into the faculty role, and the other chief of staff who transitioned out. So that mattered. The university had a policy. Virginia State University's policy stated that administrators transitioning back to faculty would receive 75% of their, or 75% proration of their former administrative salaries. So it was going to be higher than a traditional professor's role. I will tell you that while this has been boiled down to three really succinct bullet point paragraphs, this litigation had to go a good distance because, frankly, the defendant didn't do a great job of communicating how they got there at its earliest stages. Again, you heard me mention ways to get off the off-ramp of litigation. One of those is to have clear, candid conversation with people who may not want to listen, but that affirmative defense really did help them. You look at the contemporaneous documentation of the pay decision, and then the affirmative defense under the Equal Pay Act. And that law simply says that you will pay men and women the same salary for the work that they perform in a similar job. There can be differences, but the differences have to be based on certain job-related or business-related criteria. The employee cannot invent differences during the lawsuit to explain why a pay gap occurred, but Virginia State University succeeded because it had that 75% proration system. It was objective, it applied to anybody, and they had a historical record of applying it to males and females. But the pay equity and the Equal Pay Act are very real issues that you should pay attention to when you conduct your audit. We can move on to the next one now. All right, let's try this out. So we'll move down to dress codes. And, you know, it's interesting as most of us are working virtually and I'm sitting here in a polo shirt. It's a lot different than when I was wearing a suit and tie every day to work. COVID, thank you for some of that. I mean, maybe one of the few benefits. But some companies still have dress policies. So let's look at a sample dress code policy and let's see what kind of issues people might pick up. Employees are expected to maintain a professional appearance and dress accordance with these guidelines. Now, they have male employee guidelines and female employee guidelines. Male employees must wear traditional business attire, including button-ups, slacks, dress shoes, and ties when required. Male employees may not wear nail polish or jewelry other than a watch. Hair must be short and neatly groomed. No beards, no hats, or head coverings. Right. Now, female employees, what are some of the issues there? Female employees must wear traditional business attire, including dresses, skirts, blouses, or women's business suits. Female employees may not wear clothing intended for men. Makeup and jewelry should be appropriate for a professional woman. No hats or head coverings. Well, I hope a lot of you right now are just bombarding the chat and have questions. There are a lot of issues associated with this dress policy. It is a laugh out loud moment, but the fact of the matter is, what I would tell you is be careful. Within the last 4 or 5 years, a lot of you are familiar with, the name is going to escape me because I'm trying to think of it real quickly. Abercrombie and Fitch. Abercrombie and Fitch. And for those who are, into pop culture, there's a show on Netflix called White Hot. So Abercrombie and Fitch actually went to the U.S. Supreme Court to lose a dress code case. And some of these policies could be interpreted as being such. Actually, they had a policy that you had to wear their clothing. If you were lucky enough to be on the floor of Abercrombie and Fitch, and that's what the show White Hot is about, then you had to wear their clothing. Well, they had a woman there whose religious beliefs required her to wear a headgarb, a hair dress. And they said, well, no, you can't wear that, but you can wear one of our baseball caps. She said, no, that's not the same thing. And Abercrombie and Fitch felt like it was such an important issue for them that they took that litigation, not just through HR, not just through the EEOC, not just through a district court, right, but to the U.S. Supreme Court to lose because this woman had a legitimate religious reason for it. And Abercrombie and Fitch's desire to have their clothes worn by their employees out in the front, the public customer facing employees, was not a legitimate reason to limit her religious beliefs. So dress codes can be dangerous if you aren't mindful of where the law is and where it's going. So it is a wow, but keep in mind, very smart people can make big mistakes by getting entrenched in their own position. So dress codes are one of those 10 types of things to pay attention to. Let's go to one of the big ones right now. Remote workers. Again, I talked about COVID and the ability for me to wear a polo shirt, and it's fantastic. But one of the biggest things that happened is the idea that we can work anywhere at any time, thanks to the modern miracle of Zoom and Teams and all these other formats that we can pick up. Remote work is more common now than ever, but employees who work remotely, period, present a risk. And then employees who work in multiple states absolutely exacerbate those risks. So keep these things in mind. Let's look at a quick checklist. 10 items to check before every hire. One, what's the sick leave policy of other state leaves that might be applicable for your employees in various states? If you are based in Virginia, but you have employees in New York, and they are working remotely in from New York, you may very well have to be compliant with those laws in New York, not just Virginia laws. So you want to be aware of what medical leave is there, school leave. Again, many states now have leave for people to vote. In Virginia, we even have organ donation leave now. So those kind of medical leaves are critically important to think about. And unemployment insurance. Again, really outside of my wheelhouse, but I know it's an issue that all of my clients be aware of. Generally, when people are working from home, it's a pretty, knock on wood, safe environment. But there are places that require you to have gone, inspected, ensured that they have a proper place. And then you have clients who may be asking, is my confidential information, and heaven forbid if you have HIPAA protected information, is it being safely stored when you allow a person to work remotely? Keep that in mind. Does your harassment training or your EEOC, EEO policies, have they been expanded to address those different jurisdictions? And then some places require certain notices at hiring and at termination. Are you complying with those? Reimbursement rules are very real. Some states require you at the termination moment to have paid that person for all time work. Others can give you a reasonable period of time after, maybe the next pay period. But that's something you should be aware of. What severance language? If you are getting a severance or offering a severance and getting a release from someone, is your severance appropriate for that particular jurisdiction? Every state will have nuances that are there, not just the federal law. So that's one you have to pay attention to. Enforceability of non-competes and non-solicitation agreements. Everyone wants to protect their information, their company information. I will tell you, generally speaking, and I'm going to say nationwide, but each jurisdiction is different. But non-competes are becoming more and more disfavored. I think California led the way, and many other jurisdictions are following. They're very difficult to draft properly and even more difficult to enforce. So are non-solicitation agreements. Again, look back at who's exempt or non-exempt. The federal law has a level, but some states may have levels as well. Finally, I mentioned a couple things. The final pay obligations. When must you pay? Oh, yeah. Sorry, that jumped up on me, a pay frequency comment. Meals and break periods. Yeah, a lot of states require you to pay. If you have a non-exempt employee who's being paid an hourly rate, they have to be paid up twice a month. Some maybe even say 40 hours at the end of a work week. So all those things are very real for you to deal with and address. And we strongly recommend you pay attention to them. Jocelyn, I have rambled on for quite some time, and I apologize for that, but it's a lot of good stuff here.
No, you couldn't possibly apologize. This is incredible information, and I know everybody on this call is really learning and very grateful for it. So thank you so much. Before we jump into Q&A, just want to really briefly talk about VirgilHR. As I mentioned, we're an employment and labor law compliance software. We have a platform that does a number of things. So in 1 minute, I will tell you we have a chat bot. You can ask the chat bot questions. We actually have a new version of our bot coming out in the next month, 4 to 6 weeks, which we're really excited about. So stay tuned there. But you can ask it questions like, I have an employee in Massachusetts requesting parental leave. What do I do? And it will provide general legal guidance so that you stay compliant with laws that are relevant to that specific employee. We have an employee handbook builder, a multi-state comparison tool. legal updates. So as laws pass, become effective, we notify you and we provide a calendar so you can keep track of all of those effective dates as well. Job description builder, salary benchmarking tool, LMS. So chock full of different features that are available to you so that you can support the compliance requirements that you have to meet as an employer. So if you'd like to learn more, please feel free to use this QR code to book a demo with VirgilHR. It's a really great 30 minutes of your time, and it'll provide a lot of valuable information on a tool that could potentially help you save time, cut cost, and mitigate risk. On the right-hand side, Leah was initially joining us. If you click on this QR code here, it'll take you to Leah's page on the Woods Rogers website. You can find Victor's page on there as well. So if you're interested in potentially engaging with Woods Rogers, go ahead and use that QR code to get in touch with them. Our SHRM code for the webinar today is 26H3WXY. And yes, we will be sending this recording out in the next couple of days. So I'll jump straight into the questions here. One question from Kimberly is a timesheet for exempt employees required?
Kimberly, that's a fantastic question. A timesheet for exempt employees is not necessarily required. Strongly recommended, though. Listen, I'm a lawyer, so I live in 6-minute increments. I do timesheets every day. They're not a paper sheet, they're electronic. But what I would suggest to you is they serve a few different purposes. One, it allows you to assess your workforce and how much people are actually putting in. So if there's a group of people or any particular person who's putting in significant time, even exempt, you might want to know that. You might want to help assess what they're doing. And again, I don't want to sit here and tell you it's required by law, but what I would also tell you, though, Kimberly, is if there's ever a moment when that person who you thought was exempt had to be deemed non-exempt, your only record or your best record is going to be that timesheet. So for a lot of reasons, I strongly endorse timesheets for everybody. And for me, the easy answer is frankly, from CEO down. And listen, I'm asking a lot when I ask for a CEO to do a timesheet. But what I'm suggesting to you is if I can say from the top to the bottom, we're all doing timesheets, as much as anything else is designed to ensure that we know where people are spending their time, that we know what projects people are working on. And it helps us from a cost standpoint, depending on what type of work you do. It's a very long answer to a really short and easy question, but I would suggest to you, look at those nuances I talked about. I would strongly recommend it if I had my druthers.
Right. Next question. I'm a little confused about the discretionary and non-discretionary bonus regarding profit made.
Yeah, well, don't be confused. It's really simple. Go back to that slide and you'll see it when it's shared. If it's a discretionary bonus, and if the company has X profits, let's just say for sake of argument, we get to the end of the year, we've had a stellar banner year, and we reach X profits. And in the room with HR, and I'm going to say this, and this is a little nod to Hamilton, I want you to always be in the room where it happens. You make those decisions together with CEO, CFO. If you decide that we've had a great year, we want to share some of the benefits, some of the largesse of our successful year, you do it at your own discretion. You do it without any tie to the actual work that individuals did, but just to the overall profitability of the organization. And there's no agreement or expectation. That can be a non-discretionary bonus. However, if you have a policy in place, for example, that if we reach X or, pick a number, yeah, again, X profits. And if we do that, each one of you will receive, 3% of your increased salary. That's going to start looking more like a locked-in bonus, and that's going to look like a non-discretionary bonus that has to be included into your regular rate of pay and overtime. And you may have to do that calculation for an annual period. Not impossible to do, but that's something you have to do. And I hope you get the distinction. The distinction is one of them is tied to direct numbers, and it's an expectation of employees if it happens. The other, the first example, the employees had no actual expectation of it. The amount of it was going to be determined by a group of people, and when and how to distribute it was going to be determined by those small group of people and then paid out. So it's all about the discretion. That's the word in that instance, and that's the distinction between a discretionary, which can be exempted from your regular rate of pay, versus a non-discretionary, more locked in type of bonus.
Great. Thank you, Victor. Another question that came through from Kimberly. Can you explain the hourly exempt classification?
Is Kimberly the same? Kimberly's asking all these good questions. I'm just asking, don't answer that, Jocelyn. Kimberly number two. Okay, listen, I'm going to say it, I'm going to say it. The bottom line is this. Every person in America can be a non-exempt or yes, a non-exempt employee. That means you can pay them an hourly rate, and when they work over 40, you pay them time and a half of pay for that regular rate of pay. That's the first group of all Americans. Now we look at the specific, and again, I'm gonna go back to it. And if you bear with me for a second, perhaps I can put my hands on it. Um, there's a group of white collar exemptions, and those are people you don't have to pay overtime to. And the first is executive exemptions. And those are people who are supervisors. They supervise two or more employees for more than half their time. That's the technical definition. Um, and there's a fact sheet that I'm going to recommend to you, and I'm going to try to stick it in the chat if the chat will allow me to do it. And then some of you can look at this document and it'll help you. But the bottom line is you have executive exemption. Those are supervisors. After you have supervisors, you can have administrative exemptions. And let me be very clear about this. Administrative exemption is not a person who does the work that you produce. If you look at this fact sheet, it's a pretty good little document. That is HR. And I hate to say it, HR is not productive, i.e., we don't make the widgets of the company. So consequently, we are back office. Certain payroll positions, they have to have independent judgment and discretion, and there are lots of things associated with it. It's not just every person who might be in HR, but it's the HR professionals who really make some decisions about policies and procedures. Those persons can be exempt. You got the third group of people who are professionals. The professional exemption, again, the nomenclature from 1937 is different than it is today. It anticipates at least a college training and oftentimes more. The easy exemptions from a professional exemption are people who receive licensure from the state. So if you're thinking about nurses, if you work in a hospital environment, LPNs, licensed practical nurses, that's a license, so they can be exempt. I don't really like stopping right there, but she's not able to see anything in the chat. I'll let you deal with that. But registered nurses, they receive a license, so they can be exempt all the way up to your doctors. In law firms, the lawyers are exempt. Paralegals are not exempt as professional exempt, even though many good paralegals and administrative people can do as much as a lot of lawyers. It's the fact that we have the license that's been granted by the different states in which we practice. You have finally computer and outside sales. Those are other white collar exemptions. If you can't see it, let me just recommend to you go to www.dol.gov, then just type in WNL or wage and hour fact sheets exemptions, and you'll see a nice host of fact sheets that you can look at and gain some information from.
Great. I think we only have time probably for two more questions.
I hope they're
Before we do that, somebody did ask a question about our AI bot. Our AI bot only pulls information off our data that our in-house employment and labor law attorneys have developed over the last several years. So we're not using any open source, and that's what makes us a little different.
Yeah, that's a very important distinction. That closed source AI system that Jocelyn has with her group, it's absolutely pristine. That's an important thing to keep in mind.
Yeah, thank you. I thought this one was an interesting question and probably relevant to a lot of people. This is from Kendra. For remote workers, what happens when remote workers work from a different state that is not within their company jurisdiction or in another country for a short period of time, and there's no company policy that covers locations for remote work?
Kendra, that's a $1 million question, and I'm going to jump out the window on that one. What I'm going to tell you is this. That's probably happening and being observed in the breach more than the compliance. Again, with remote work, many people take their work and their ability to access company information across many different borders and jurisdictions. It is going to be a state-by-state specific answer to your question. So I'm loath to give you a universal one. But what I would tell you is this. If you hire someone who you know resides in a different jurisdiction than your own, that's where you want to. And again, many good lawyers and myself and perhaps Jocelyn's, software can tell you some of the risk associated with having a person pick a place, work in the Commonwealth of Virginia for a company, but they're residing in California. I will tell you that when you have that, it is more likely than not that you're going to have some compliance components associated with California law. So, Kendra, what I would tell you is I would get my hands around the people who have access to our resources or the work that we're doing and where they're having it. I don't want to be an alarmist, Kendra, and tell you if somebody goes on vacation, down to the beach and they take their laptop and they do something for 15 minutes that you should be overly concerned about that. I don't want to say that, but I am going to tell you that the moment you have a good feeling or a sincere feeling that someone is working remotely in a different jurisdiction, it does increase your exposure. And that's a situation that you should pay attention to and begin to do some research on how viable that is. Because many employers will then have to make a decision about whether that person is worth the associated risk of being in a different jurisdiction. So it's a big question, Kendra. It's a legitimate question, but one that requires a little bit more than we can do right here.
Yeah. And with that, I'll close out just by saying, as always with our webinars, they are educational in nature and they don't constitute legal advice. So if you do require any legal advice, please feel free to reach out to your employment and labor law attorney, or in this case, Woods Rogers. As you can see, Victor is amazing. So they've got a good group there, and I'm sure could help you out as well.
We do indeed. Thank you.
Victor, thank you so much for joining us today. I really appreciate it.
It was absolutely my pleasure, Jocelyn. Thank all of you for being there. I hope it's many of you, and I hope it was worthwhile. Take care.